By law, in every divorce in California, whether your marriage was just a month long or 30 years long, both sides are required to complete what are called preliminary declarations of disclosure. Sometimes the shorthand is just financial disclosures. But basically what this is a set of forms that requires both sides to disclose their income, their expenses, as well as their assets and their debts. Now, on these forms, particularly when it comes to assets and debts, you're expected to list not just those assets and debts that are in your name or that are in your possession, but any asset and debt that you're aware of, regardless of who you think it belongs to and whose name it's in. These forms are not only required, but also extremely useful, both for litigants in pro per and for lawyers. A lot of people coming out of a marriage don't always know what the income of the other party is, what assets and debts they have. And without that information, it can be very hard to negotiate and try and reach a deal or to prepare for trial. If you have questions about filling out these forms, we do recommend speaking to a lawyer, even if only to go over the forms themselves. Judges and courts look at these forms regularly. Lawyers and the other side in your case will be looking at the forms in order to see what assets matter and what they may or may not have a claim to, and the forms can even be used as a basis to argue and analyze the correct child support and spousal support amounts. In general, everybody's going to have to fill out these forms at least once in their divorce, maybe more, and filling them out correctly and in a way that benefits your position can be extremely advantageous.